Good morning, Ms. Mr. Anahoily, good morning.
Good morning, Your Honor. May it please the Court, I am Kevin Anahoily, and I represent the Commissioner of Correction. And the issue today is whether the lower court properly decided whether the Commissioner of Correction exceeded his authority in promulgating a regulation that charged restitution for inmates after they were found guilty of a disciplinary violation. I direct the Court's attention to three statutes which essentially give the Commissioner the authority to take the action that he did in this matter. The first statute being Mass General Law, Chapter 124, subsection 1, subsection B.
Subsection 1, subsection what?
B.
B.
E1?
Yes.
You mean section 1, subsection?
I'm sorry, yes, section 1, subsection B, Your Honor. That subsection requires that the Commissioner take all necessary precautions to maintain order within a correctional facility. The second statute that's in question here is Mass General Law, Chapter 127, Section 33. The language that's important in that section is that it directs superintendents of facilities to use all necessary means to enforce obedience and suppress insurrection. And finally, the third statute that's important is 124, Section 1, subsection Q, which gives the Commissioner the authority to promulgate rules and regulations in carrying out his authority. And specifically, that section gives the Commissioner authority to do so in areas of discipline.
Mr. Anahoily, excuse me, Justice Watson, go ahead.
The question I had was whether you are aware of, in any other part of the general laws, any other agency that exercises the power to take money in restitution without a specific statutory authorization to do so.
Well, I would submit, Your Honor, that there is a statutory authorization.
There's no mention of restitution in any of the three that you've talked about.
There isn't, Your Honor, but there is a mention of discipline. And what this Court must decide, and I think what the issue essentially boils down to is, does restitution flow from discipline? If that's a rational occurrence of discipline.
But restitution is taking somebody's property, correct?
Taking someone's property in this instance only after they're found guilty of a disciplinary infraction and have caused harm to the Commonwealth or the Department in some economic harm in some sense.
Can I ask you, though, it just struck me as I was looking at this issue in the briefs that there are two issues, and maybe they're properly conflated into one. One is the power of the Department to promulgate a regulation in which restitution is a sanction that may be imposed after an appropriate disciplinary hearing. The other is the power to simply debit or forfeit funds that are in your possession as a sort of a trustee, just to sort of credit or debit against inmate accounts. That seems to me to be a separate issue. Is it or not?
Well, I think it's not, Your Honor, and the reason why I think it isn't is if the one didn't follow the other, it would render useless the restitution sanction. For instance, if...
Well, more difficult, I assume. I mean, you'd have to collect it perhaps in a different way. Once you have the restitution order, you might have to collect it differently, you know?
Well, in instances of this, I think it would render the sanction teethless.
Not at all, because you might have to, for example, if one obtains a judgment against, if a bank obtains a judgment against somebody for whom the bank is holding funds, the bank usually can't just go and attach those funds. I mean, which is not to say you couldn't get access to the prisoner's account, but they might have to, I think Justice Cordy is probably correct, there might have to be some...
Is there a further step? Either you have to get an order or...
Along those lines, is there a regulation that tells the inmate that if he breaks a rule and the department adopts some reasonable prophylactic measure to prevent him from doing that again, that the department is prepared to impose the costs of doing that on him? Is there a regulation that says that?
Yes, Your Honor.
Which one is that?
Substance abuse regulation.
What does that say?
That says if you violate the substance abuse rules, meaning if you're found, in this instance, if you're found with home brew in your cell and
Yeah.
you've taken that, the commissioner will impose a sanction of mandatory monthly testing, and you will be charged restitution for that.
And which regulation is that?
That's not a regulation, that's a DOC policy.
Is
That's-
it in writing?
It is in writing. It's attached to my brief, Your Honor. It's 103 DOC 525. It also is included in the restitution regulation. And in fact, Your Honor, it's been included in that regulation since the initial promulgation of that regulation in 1978, 30 years ago. So
Mr. Anaho-
restitution has been a
Well,
sanction
but-
in place.
Okay.
Miss-
What does the regulation say that you?
It says if an inmate is found guilty of a disciplinary infraction, restitution can be a sanction that is used to make the
But this
Commonwealth
isn't
whole.
restitution.
Yeah, and that was my point.
This isn't restitution. That's when your policy 103.525 seems to speak to this. But the regulation, that's the one that I read in your brief. The regulation about sanctions. This isn't a the regulation about restitution. Restitution is to make someone whole. You've imposed this as a sanction, you say.
Well, it really isn't a sanction in terms of if you're interpreting it to be a fine. That's not the case. What is happening, Your Honor, is there.
But restitution is like if you damage my car, you pay me to make me whole so that my car is fixed. But that isn't what this is.
Well, I think it is because what is happening is the institutions or the department is paying for these mandatory monthly testings, which would not have to take place if it weren't born out of the inmate's misconduct. In this
Mr.
case.
Anahori, I understand that. I have several questions, one of which relates to Justice Cowan, which is what's the nomenclature here? For example, the legislature has said that when defendants are placed on probation, there will be a probation fee charged. That's essentially to bear some of the costs of probation. That's typically not considered restitution. So, viewed one way, the commissioner may simply be using the wrong term, because I agree with Justice Botsford. Restitution is not for administrative costs. But the second is, from my point of view, the question is, does the statute permit that? If it's discipline, it tends to slop over into a sanction. If it's simply the ability of, for example, if a inmate is placed in solitary confinement, I take it that that requires more personnel than when you have somebody who's not in solitary confinement. By the commissioner's argument, it would be appropriate to say to the inmate, well, we can have restitution by charging you the additional costs of putting somebody in solitary confinement.
In practice, that doesn't happen.
No,
Your
I
Honor.
understand that. I'm trying to find how we are actually looking at this, and the question is simply, does the statute authorize this? You are aware that there are many other statutes that deal with, quote, restitution, saying somebody can, including the commissioner, can have restitution for this, restitution for that, correct?
Well, I would say, Your Honor, the statute in restitution, as the department terms it, isn't imposed until the inmate has an opportunity to be heard.
No, we're not considering here, I don't think, a sort of due process. I mean, there may be an underlying due process. I mean, that's not the issue.
Well,
the issue is this, whether you view it as a sanction, a repayment to the commissioner and the department, a penalty, a fine, and whatever name you put on it. Did the legislature contemplate that this was what the commissioner could do?
I take it if you present it as a disciplinary matter, right? That's how you justify it, correct?
Right,
So it does fall within the sanction.
And I think this
group of
court,
things.
in the Sepalonis decision, in dealing with the restitution in an issue where double jeopardy and how it relates to criminal matters, found that a fine was appropriate in that it provided a deterrent element and a remedial effect. And I think my brief cites to that case. So even if this court were to
You're talking about the appeals court Sepalonis decision, or
No,
our,
this
No.
court's
our
decision.
Sepalonis
Yeah,
decision?
our Sepalonis case, I take it, as I recall, the sanction imposed under the same, well, basically the same CMR, 103 CMR 430, blah, 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 for violation of the regulations, the sanction was restitution of $10,774, which was the cost of what, bringing him,
Apprehending him. Your Honor.
apprehending him.
And the plaintiff in that case mischaracterized the restitution and called it a fine, and this court determined in that case that the fine, which was really restitution mischaracterized, had a remedial aspect in that it had the apprehension costs and a deterrent effect in that it had consequences. It demonstrated to inmates that consequences of bad acts had consequences. Similarly,
So you're saying that this case is governed by Cepalonis?
I'm saying that it does have bearing on it. Yes.
Cepalonis didn't deal specifically with whether the restitution order itself was authorized.
It wasn't a facial challenge to the
It was a
restitution.
double jeopardy challenge to whether or not he could then be prosecuted.
Yes, Your Honor.
But back to the sanction, if you're saying this really isn't the cost of testing for 12 months, right?
It is the cost of testing.
Well, except I thought I saw somewhere in here that for the
File.
something that causes the commissioner to incur additional costs, we can charge you for those costs. We can charge you for overtime salaries, correct?
Yes, Your Honor.
We can charge you for, medical expenses. If you break your arm, we can charge you for that.
Well, they can charge you a copay, Your Honor. They're not seeking reimbursement for.
But the commissioner's decided that, but the commissioner could say, under your theory, we want to charge you for the full cost. If you can charge for the full cost of drug testing, you can charge, the commissioner saying he has or she has authority.
Well, I think there's a difference here, Your Honor, in terms of the drug testing. The commissioner doesn't charge inmates for the mandatory testing that takes place separate and apart from the disciplinary sanction. For instance, I believe 10% of the population is subject to mandatory random drug testing.
Because is that related to their sentence?
That's related. That's because the use of alcohol and narcotics in prisons is the Supreme Judicial Court has found that that's a
So this is, I'm sorry, random.
random
I'm
testing.
sorry,
We don't charge for that, Your Honor. We charge only in the specific instance when an inmate has been found guilty.
No, I understand
of
that. I'm trying to
violating the
understand the
trust of the-
scope of the authority that the commissioner is looking for here. In other words, if we say, yes, this is restitution, we are saying essentially the commissioner is free to characterize almost anything as restitution provided that it's linked to discipline.
Well, I just want to, I see my time's running out, but I want to make it clear that the commissioner is only using restitution after an adjudicatory hearing
No, of
that's
course.
subject to a certiorari action and review in the courts.
Well, but is there any attempt to distinguish the circumstances for which restitution might be imposed? For instance, this does not sound like what's concerning me, but there may be a classic common law kind of violation for which somebody would be entitled to a jury trial. You maybe destroyed somebody's property, and if you wanted to recover for that, you might be entitled, the person against whom the remedy is sought might be entitled to a jury trial. Is there any attempt to make that kind of a distinction?
No, I think the code of offenses spell out what an inmate, when they come into the prison, they're giving an orientation handbook. These are the rules that you have to abide by. Failure to do so may subject you to disciplinary action.
Well, could you punish somebody by taking away their right to vote?
No, I don't think that's a disciplinary sanction. If that's what
May
you're
I
saying.
ask you this? What about if we agree with you, and the idea of restitution is the approach that's used, what about the inmates who don't have any resources?
What happens in those instances, Your Honor, they're charged restitution, and their account is frozen, subject to money coming in, and if it does come in, then the money's taken.
Uh-huh.
If
If it doesn't come in?
that freeze remains in place, and it remains in place until money does come in to satisfy the
And if it never
restitution
comes
amount,
in,
then it stays in place, Your Honor.
No,
Then-
but what about when they're released?
then when they're released, what happens?
When they're released, it just goes away, essentially.
Could the commissioner then file a lawsuit against them for monies owed?
I suppose so, yes. I mean, I think if restitution were to go away, that would be the last alternative for the commissioner to seek, and that would be small claims judgments and
Well, it's not
thousands
small
of
claims.
actions.
It's not small claims judgments because some of these are in tens of thousands of dollars, aren't they?
Well, I mean, it would matter on the issue,
Mr.
but some
Anahora,
of them
I know your time is up, but as a practical matter, unless an inmate has family resources, as a practical matter, anything that the inmate wishes to acquire, like toothpaste and soap, that has to come out of his or her account, correct?
No, not there are certain requirements that they have to get, and that toothpaste and soap fall into that.
Necessities.
Necessities, they're given that. And just to quickly go back to your point, Your Honor, he can work, or she can work in the institution to work off that restitution amount. There are plenty of jobs available to inmates within the facility, and they are compensated for those jobs.
Someone just characterized these as in the tens of thousands. Are they typically in the amount, as in this case, of $100-some-odd?
Most typically, they're the substance abuse.
So
There are
the
instances,
testing
substance
costs.
abuse testing costs. There are instances where they're $1. There are instances
No,
where
I understand
they're
that,
72
but
cents.
again, you're looking at the scope of what the commissioner claims that he or she can do. Thank you, Mr. Anahori.
Thank you.
Mr. Eslich?
Good morning, Mark Estrich representing Dennis Ciampi. It's our contention that there is absolutely no statutory provisions authorizing the DOC to seize money from a inmate's account as restitution for a disciplinary offense. And I believe the Chief Justice hit upon a very important matter, the scope of the authority. Obviously, in the statutes, there are catch-alls to promote harmony in the prison, etc. But nowhere in the statutes is there a direct authorization to remove money from an inmate's account.
Mr. Eslich, but, I mean, if the commissioner, somebody's caught with a very serious offense, substance abuse, right? That's a serious problem in prisons. And one way to deal with that and to make sure that this particular inmate doesn't repeat the offense is to test, correct? If the inmate knows beforehand, you violate in this way, we're going to test, we're going to discipline you and we're going to test you, prophylactic discipline, why shouldn't that inmate bear the costs of that? Assuming that that they are real costs. I mean, and I understand there's not a challenge here, am I correct, to the cost?
Well, my argument is that this cost is an administrative expense. They have a lot of other resources at their disposal in terms of things that affect their day-to-day life. They can take away a lot of privileges, almost all their privileges, any social privileges, no communication, isolation. This cost is really an administrative cost. Just talking about this, going back to scope of authority, if, this is an extreme example, but if a person is found guilty and sentenced to death and is electrocuted, you don't present their estate with an electric bill for the cost of executing them. Just as you said, I made the same note that if a person is placed in solitary confinement, obviously there's a further cost because of the added manpower, et cetera, but this is just a cost associated with running a prison.
What do you do with the statute that says the commissioner has authority to promulgate necessary rules and regulations incident to the exercise of his powers and so on, dealing with issues of discipline? Why isn't that enough authority to create this kind of regulation? And why should we get hung up on the word restitution? It's really a matter of repayment of costs of discipline.
Well, in answer to that, I believe what really is the crux of the matter here is what is the legislative intent? And I submit that the legislature has enacted a lot of statutes that allow removal of funds from an inmate's account for an unconnected laundry list going from haircuts to medical services to witness assessment fees, and nowhere in there is there anything regarding a forfeiture for disciplinary reasons.
But it's not a forfeiture. It's not a forfeiture.
Well,
it's repayment of an expense that he called when he's in his cell trying to make moonshine.
But I submit that this is more of an administrative cost. It's not a restitution. It's not to restore the prison to its...
But it's an unnecessary administrative cost that the prison officials wouldn't have to undergo, but for the already adjudicated bad act of your client.
Once again, in the same argument that an individual placed in solitary confinement is placed there for bad acts, not for being a good person, this is just the cost of running a prison. And I submit that these...
Well, it's not because the inmates should not be using drugs. But on another, I also want to ask you, you suggest there has to be some discipline, you admit, for when the inmates break the rules, particularly serious problems. Okay. And you suggest other ones like isolate, solitary, loss of social visits. I would think those are so much more serious consequences that an inmate wouldn't want them. I mean, I read the penalties here, and at one point there were a year loss of contact visits, social visits. I mean, that seems to me a horrendous loss. The inmates have, most of them probably, as the Department of Correction person said, there isn't money in the account anyway. So it's virtually meaningless. Whereas if you put them in isolation, or and add to the numbers of days of isolation because of the cost, or if you destroy, if you negate their visits, and that would seem to me so much more serious.
I'm in full agreement. Then
so
for that reason, this doesn't serve as a deterrent in any respect.
Right, I'm sure that's true. So what should the prison authorities do?
Well, the prison authorities have other means at their disposal.
What?
Taking away privileges, taking away library privileges, taking away social privileges.
Well, that's what I just said. Taking away social privileges are very serious for people
That's not the question. The question is this regulation authorized? The question is not, do they have other alternatives? Of course they have other alternatives.
Of course, that's the crux of the argument. And I submit that it is not authorized by any statutes And it is not the legislative intent that this type of sanction be allowed
Agreed.
against a protected property
This is a
right.
very serious offense. You would agree with this?
Of course, it's a serious offense.
Mr. Eastridge, let me ask you this. The point that I think is most persuasive is the fact that the legislature has specifically authorized by statute, not just once, not just twice, but repeatedly, the circumstances in which the commissioner is authorized to get access to a prisoner's account, correct?
That's correct.
Have those, I haven't looked at the full statutory history, some of which could be deemed a, quote, penalty, and the legislature said, nevertheless, you can go in and take the money from the prisoner's account. Have those accrued over time at the request of the commissioner? In other words, in prior decades, because I think these were enacted over a period of time, did the commissioner go in and ask for permission?
I don't know the historical answer to that as to why these statutes were expanded, but I do know that in 1999 an amendment was made to Chapter 124, Section 1. Section R was added, allowing a deduction for haircuts. Then in 2000, deduction was allowed for medical and health services fee. In 2003, a deduction was added for administrative fees on prison bank accounts, not bank accounts, but the accounts at the prison. So, as you can see, over a period of 4 years there, they made 3 specific additions to the permitted withdrawals from a prisoner's account.
But as I understand it, for at least for the last 30 years, these regulations have been in place. This has been the practice. Is that correct?
As far as I know, it's been the practice, but it hasn't been challenged.
And
it hasn't been.
Why amend if there's already a regulation, or excuse me, a statute in place that permits the commissioner to set up a disciplinary system and to promulgate regulations to ensure discipline and security in institutions, and this has been part of that for 30 years. Why amend the statute specifically to provide for that when it already exists?
Just because the issue has not been brought in front of this body doesn't mean that it's not a good issue, or that the past practice means that it's correct. It could be the incorrect past practice for the past 30 years. And that's really why we're here, to get your decision to authorize this.
All I'm suggesting is that on the subject of discipline, it is quite clear that the commissioner has broad authority to promulgate regulations to ensure discipline. That includes regulations, due process-related regulations, enumerating violations, providing for sanctions. I mean, that is a gigantic area.
100% agreement. There's a huge catch-all, and that catch-all has to be balanced against these individual authorizations to try and get
but
at
you're not related to discipline by and large.
By and large, you're not. But some of them are.
There's
for
one
example,
little section in R or Q or something like that which talks about deductions for an injury
cause
inflicted
to
on
themselves
another
or to
inmate.
others. Right.
Medical costs.
Medical costs, exactly. So that's what has to be weighed. Obviously, there is a huge catch-all, and if you hang your hat on that, then my argument is not going to succeed. But to the contrary, there are all these individual authorized deductions. Now, just to show how another state handles it, New York has a very similar statute, but they add the little phrase that the commissioner has authority over fiscal concerns.
No, but I read that. I mean, I took the fiscal concerns to be of the department, not of the inmate.
Well, I took it to mean of the inmate as well, but there's nothing even approaching that anywhere in our statutes. It's conspicuous by its absence. I'm sorry. And when you do remove money from a prisoner's account, even though he's a prisoner, he still has rights. He has a vested property interest.
We understand, and that's why it couldn't possibly happen without a hearing, an opportunity to be heard, and that's precisely what the disciplinary process provides, doesn't it?
It does provide a hearing, but much like the Procurator of Judea, the commission is both judge and jury. I don't know how. It's certainly not as fair a body as we have here.
There's a disciplinary committee, presumably. I can't remember precisely how the structure works, and then there's an appeal to the commissioner, right?
And I submit that very few of these appeals are upheld.
This one succeeded.
We're in front of a different body here. We're not in front of
No.
The penalty was reduced.
The penalty was reduced, but it wasn't overturned.
You don't, I mean, you do see a difference between this case and the Welch case that Judge Craftsey relied on, yes?
Well, I believe that the Welsh case was clearly totally administrative.
Right.
But I feel this case is only a lateral pirouette away from that case.
Well, no, the Welsh case is more like the cost for the random urine analysis that takes place.
Well, not necessarily, because that was
it's something
a mandatory DNA test.
Right, and that was Welsh, but that's mandatory, and that's done to everybody. So that isn't being imposed. It can't be imposed as a disciplinary means.
Granted, it was not a disciplinary matter. But as I stated earlier, I maintain that this is closer to an administrative cost than to a restitution cost, to a restorative cost, to a retrospective cost. This is a prospective fee over a year.
But it arises directly out of the violation of a reasonable prison regulation, and it seems as though it's his misconduct which caused or provoked a particular response from the prison officials at a cost to the prison system, and he should bear that cost.
I grant that, but in the same fashion that an individual placed in solitary confinement does so because of his actions, but he's not charged for the extra expense that it costs to put him into solitary confinement.
Well,
Apparently not yet.
Not yet, at least, yeah, apparently not yet. We don't have any case law yet saying an individual can be charged for the extra cost for being a quote-unquote bad prisoner or a bad apple or something like that. And in this case, I believe it falls under the same umbrella, the same ambit. This is just the cost of running a correctional facility. And I don't believe it's the legislature's intent that you pass on every cost to the prisoner beyond the 3 meals in a cot, the minimum requirements. I don't see anything in the statutes saying that every cost has to be passed on.
But it has to, but I mean, that's not the argument. The argument is not that it has to, but that the commissioner has the authority, should he or she feel it's related to discipline, to impose them.
But where do you limit the scope of authority? I submit that the scope of authority is limited by the statutes.
Reasonable.
And what is reasonable?
Well, it would certainly seem that the costs of these tests, which are modest, even by an inmate standards, are modest, would be reasonable.
And the fact
whereas the costs for an extra person to watch the inmate in solitary might not be reasonable.
And the fact that they're modest it argues to the fact that it's a cost that should be borne by the person. It's so incidental. And even getting into the fact that an indigent prisoner is really going to suffer if he can't.
This is $6 a month, is that right? Or $6
$12 a month.
And they can earn how much? $10? How often by working?
Well, that's another point. You are allowed to work, but that's another right that can be taken away from you. The right to work. Not every prisoner is allowed to work. It's more of a privilege than it's not a right. It's a privilege.
So if there's no money in the account, the prison doesn't get any money.
If there's no money in the account, the prisoner doesn't get any money. He gets a very bare minimum of.
Oh, the commissioner doesn't get any.
Oh, the commissioner doesn't get any money. Yeah, right. If there's no money in the account, the commissioner doesn't get any money. But the prisoner suffers as well. They just get a bare minimum of soap, toothbrush, etc. It's really a very, very bare minimum. Virtually anybody in the prison is going to improve their standard of living by having a job. But by the same token, it's still a privilege. It's not a right that you're entitled to work if you want to.
Thank you, Mr. Estridge.
Thank you very much.